Hello everybody, I'm Michael Redden and I'm an estate planning attorney here in Minnesota, and I just kind of want to talk to everybody today about what an estate plan is. And you may not realize it, but if you don't have one, if you think you don't, if you've never gone to a lawyer, you've never gotten a will or anything like that, you've got an estate plan. An estate plan basically means that should you pass away or should you become disabled and not be able to take care of yourself, then there's instructions laid behind for what to do with your things and how you should be taken care of. And estate planning is basically the process by which we go and formalize that in a way that when we're gone, either a court or a family member or someone else knows what to do and has all of the ability to take care of those things and take care of us. And one big thing to know is, like I said, everybody has one. Even if you didn't go to a lawyer, there are laws in every state called the laws of intestacy. And what these laws say is, hey, if you didn't have a will, if you didn't have a trust, no worries. We're going to figure out what to do with these things. And most of the time it says it's going to go to your spouse, and then after your spouse, your children. It goes on and on and on down the line. Sometimes these statutes let you go all the way out to 7 or 8 steps removed because we want to know where to put your stuff. And there are other forms of estate planning, as you might know, one of them being a will. A will is just a document that says, hey, when I pass away, I want this one person to take care of all of my things, pay my bills, and then transfer everything to my heirs. A will is the traditional estate plan. There's just one big thing you've got to know about them. If you choose a will, then you're going to go to probate. Wills need to be probated, and wills also don't cover anything while you're alive. And again, what's probate? Probate's just a fancy process by which we say the stuff that you owned was titled in you and you're dead. Now you got to move that title to someone else, and that's the process that's done for when you've passed away. A will is a common element in many estate plans. Even if you've got a trust, you're still going to have a will, and we can cover that in a different video. Another common estate plan is a trust, especially a revocable living trust. And these things go into effect while you're alive, and if done properly, they can kind of help you avoid probate. And why do they affect while you're alive? Because essentially you don't own the stuff anymore. The trust does. You could be the trustee, someone else, but since that trust, just like a corporation, is a person, it's a real person. We can tax it, we can see it, the courts can touch it. Because of that, when you pass away, we don't need probate. There's not a deceased person, someone who doesn't really exist anymore that owns these things. And some of the reasons you might choose one or the other usually has to go with control. With a will, there are certain things you can do and that you can't do. And with a trust, there's just other things you can do and other things that you can control. Even businesses need estate plans. What happens if you pass away? What happens if you become disabled? That business needs to be able to continue forward, and there are certainly ways that is done in the law. Even if you haven't come to an agreement, every state has laws, just like intestacy, but they're for LLCs or partnerships or corporations, about how these things occur. And the big thing to remember about estate planning is, if you don't want to fall back on just what the law says, these one-size-fits-all programs, these programs that can have unintended consequences, that can disinherit people or give you a little less control, that don't protect them from their heirs from themselves or their creditors. If you don't want any of those things, then you need to have an estate plan. And it's really important to think about where you want these things to go and what you want to happen to your things. This is about more than just avoiding probate. A lot of people think, hey, I just want to avoid probate. Probate's easy to avoid. We can put a beneficiary designation on just about everything, but just handing things out right to people often has unintended consequences, And what you should look for is an estate planning attorney who will sit down with you, go over your wants, your desires, find out what your concerns are, and help you put this down into a plan that will work. Because the most important thing about your plan is that it's one that you'll follow. If you won't follow it, if you won't update it, then it doesn't do you any good, and you're going to fall back on either the laws of intestacy, or you're going to fall back into probate if that's what you didn't want to do, and things aren't going to kind of happen with that. Another thing to remember is most people are going to have a trust of some kind, and that's because lots of times wills will make trusts. So if you say, I don't want any trusts in anything, then just realize that that can sometimes be difficult or have other unforeseen consequences, especially if you've got minor kids behind. You can't just give someone under 18 all of your stuff unless you want to involve the courts and everything, which you can do. But that's just one of those things that you got to keep in mind is don't think of these things as I want a will and I don't want a trust. Think about it as there are certain features of each tool that I want, and they kind of fit together in a plan. And if I don't make my own plan, then the government has one for me. And that's all for now, but we will be producing more videos and coming up with more content for you guys so you can understand this process, understand business processes and other things. If you're interested in talking to me about any of this stuff further, there's a link below that you can click on to contact me or set up an appointment. Thanks.